Good morning, everyone. Just wait a minute while everyone's coming in from the waiting room. Well, looks like it's coming in pretty quickly. So while we're doing that, I will get started with our preamble, our just thoughts before we start answering your questions. The first thing is our reminder from every week that this conversation is just general information. It is not legal advice. If you have a question for your community or yourself, please consult with your own legal counsel. Um, Also, that similarly, the chat function on here is really intended for requests to us for clarification or additional questions if we have additional time, which we may today. It is not intended for a place to have to discuss legal advice or provide legal advice. So please refrain from doing that if you can. As I said, we may have some additional time today for other questions. So if you have something that is burning in your head and you did not get to send it ahead of time, go ahead and pop it in there and we will try to get to it at the end. We've had some conversations, I think, before in this group and then also just internally as a firm about AI. That's sort of a hot topic right now. And we wanted to remind everyone that even using AI to ask legal questions or explain legal concepts, you don't always get correct results. We did a test where we asked an AI engine to give a short statement on why AI should not be used to provide legal advice, and it told us it should not be used because it cannot reliably interpret statutes, case law, or fact-specific circumstances, and it may generate incorrect or incomplete guidance that exposes individuals or organizations to significant legal, financial, and ethical risk. So if AI is telling you that they're not good enough to provide you with the answers you need on a legal basis, I think that's pretty telling. It's kind of, only good as what the information going into it or what it's using to synthesize that information. We're seeing even just the questions to us sometimes are expansive and clearly created by an AI tool. So, think about that before you're using that to ask for your legal information or to synthesize something that an attorney has provided to you, and just talk to your attorneys if you have legal questions. And we also just want to note that almost every week on our listservs and in our notice boards, we're noticing that attorneys are being sanctioned for using AI. So there's definitely some issues because it creates false cases, it creates false information. So really caution if you're looking to rely on that for any information. We want to do a final or an update on the CTA. Some of you have seen that's the Corporate Transparency Act. It kind of made a big buzz about a year and a half ago when all community associations had to register their boards and information about their boards to the government. The U.S. Treasury's Financial Crimes and Enforcement Network issued a final rule last week that basically absolves community associations and U.S. persons from reporting that information, and they have promised to delete all the information that they obtained through that system. I think that's in process now. They're promulgating the final rule, and it should be published. So if you have further questions about that, you can ask your legal counsel, or if we have more, we'll update you at a later date. Anything you want to add to that, Jennifer, that I missed in
No, I
those
think you
notes?
covered it.
Okay, do you want to get started then?
So let's get started. The first question, I heard one of the moderators say homeowners can challenge a board decision within 90 days. What is the procedure for the homeowner? What is the board required to do and when? And what is the specific RCW this falls under? And Chelsea, could you put this statute in the chat, please? Um, so I'm going to start with a specific statute. This is 6490-445, subsection 2, subsection L. And since this is RCW 6490-445, this is applicable to all community associations in Washington State starting January 1st of this year. So this is applicable to everyone. It doesn't matter what statute you're currently under. The purpose of this statute is to allow homeowners 90 days to challenge board procedure. It is not to challenge a substantive action by the board. So the statute says specifically, even if an action by the board is not in compliance with this section, meaning the meetings and how meetings are held statute, 6490-445. It is valid unless set aside by a court. An action seeking relief for failure of the board to comply with this section may not be brought more than 90 days after the minutes of the board of the meeting at which the action was taken are approved, or the record of that action is distributed to unit owners, whichever is later. So if an owner believes that a procedural action, such as not allowing owner comment or not giving enough notice, etc., if the procedural action is improper, they can start by contacting the board or manager and explaining why they believe that the action taken was improper, whether related to the process or the substantive issue. Owners can always address the board regarding pretty much anything. It's just this specific statute only relates to a procedural violation. So if the owner is correct about the procedural violation, the board can reconsider or correct the process for adoption of the action. If the board declines to change their action, for an owner to challenge the action successfully, they must sue the association within 90 days of either, there's two things here, the minutes of the meeting at which the action was taken are approved, or when a record of the action is distributed to the owners, whichever is later. So one assumption in this statute is that approved meeting minutes will be distributed to the owners so they are aware of the action. If minutes aren't distributed, notice can be provided to all owners of the action taken. That will also start the 90-day time period. So if an association for some reason makes a procedural violation, the minutes are not distributed to the owners, and then the action that the board took is never disclosed to the owners, the 90 days never starts running. So that action can be challenged in perpetuity, probably. But also, this is just for procedural violations. So if an association is following their duty of care, acting reasonably in the best interest of the association, it's likely you're not going to have a problem here. If there is some sort of procedural mistake, such as forgetting to give the 30 days notice to owners of a rule change, if an owner challenges the board regarding that particular issue, it's a fairly easy fix. Substantively, if this statute does not mean that a board can take whatever action that they under anything, do anything that they want to, and then the owners only have 90 days to contest. This is only for procedural violation, like not giving enough notice for a meeting, etc. Owners always have the ability to sue the association for a violation or for exceeding the going against the board's duty of care or any sort of substantive violation of the governing documents, like approving a capital improvement that is greater than what is allowed in the governing documents and just doing it anyway. So this is not meant to allow boards to do whatever they want and then owners only have 90 days to challenge. This is only for a violation of the meeting procedure. And we strongly recommend boards be very cautious in this area, and please do not be a test case. There is no case law on this particular statute yet because it is fairly new, but the statute itself is very clear that it is only for violations of the meeting procedure. It is not for substantive action. Lisa, did you have anything to add to that?
Nope, I think you covered it. I'll move on to the next one. The next question is, under Wakaiowa, can a board adopt a policy that provides for blanketed approval if the community association management company deems the submitted request valid and that it was properly vetted if needed? For example, if an owner needs a service animal in their unit, could the board provide blanket authority for the manager to approve that? And the answer is the statutes are pretty unclear about the authority to delegate. There is one reference in the statute, 6490-435, about delegation to managers. And it says that the organizational documents, which is a pretty defined term in the statute, dealing mostly with articles, but not limited to, but like the organizing documents of the association with the Secretary of State. But if the organizational documents, they could specify what powers the board could delegate to the manager. Most do not do this one bit. So this would be sort of an irrelevant, caveat. There is a section in 445, which Jennifer was just talking about, that talks about committees exercising board powers, but it doesn't mention managers. That's subsection 5. And so given the fact that there really isn't much out there, there isn't much there about whether or not there's delegation authority to a manager, we'd recommend against managers, generally speaking, being authorized to take action in place of the board if the board's goal is to avoid the open meeting requirements of the statute. If this is sort of a, we don't want to meet, we'd rather the manager just handle this, and so we only have to meet 4 times a year, or we don't, or not have to discuss these things in front of the owners. That's not really what this is intended to cover. It's risky on a couple levels to have this kind of authority delegated in the manager. There are definitely lots of things, but the contract you have with your management company almost certainly has an indemnification clause that requires the association to pay for any defense of the management company if they make a mistake, or except if there's gross negligence or willful misconduct. So if you're delegating your authority to your manager, the association still keeps all the risk with that decision, whether the decision was made properly or not. This is not casting aspersions on the management. It's just you're getting rid of the sort of the goal of the board, right? You're elected to make decisions for the association. And so that's where the risk should remain, right? If you have written policies or guidelines and decisions that might fall under those could be considered ministerial in that way, and it might be a low risk to delegate. But anything that requires evaluation, discretion, an interpretation would probably be a little bit risky, in our opinion, or high risk actually, to delegate that decision-making authority exclusively to management. But things like paying your landscaper, paying utilities could be delegated safely as long as the invoices are being reviewed by the treasurer or the board, and you're keeping track of the expenses and making sure that the budget is being respected. Sometimes some boards have things like X amount of dollars is authorized to be spent by the manager in case of a plumbing emergency, etc. That's probably something that would be a safe delegation of authority to have. But a more, on the other side of it, more risky thing to delegate would potentially be something like determining if it's a violation of policy or rules, or sending warning letters without any oversight from the board. The board has, as Jennifer had alluded to before, a statutory duty of care to act, and they have to do that on verifiable information, and they have to perform reasonable investigations. We've talked a lot in prior Zooms about the Risk v. Angel case, and so you can look back to see more discussion on that. But the board's job is to evaluate verifiable information and investigate reasonably based on that information. Certainly, if you have like a fair housing complaint or a reasonable accommodation request, that's going to you're going to want the board to look at those, and probably maybe even your attorneys, to make sure that you're doing things correctly. And again, that statute that I was mentioning about, the only place we noted that there was a delegation discussion is 6490-435, and it says, unless provided for in the declaration, the organizational documents of the association must, if applicable, specify the powers of the board, and they may delegate to other persons or to a managing agent. That's sort of that one thing, but it's got to be pretty specific and pretty, as we said, the organizational documents is a defined term in the statute, so it's got to be right in there about other delegation of authority to the manager. Hopefully I didn't talk too much around that. Anything you want to add, Jennifer, that I missed in that?
No, I think you've covered it.
Okay.
So our next question, and has multiple parts. Can an association use their reserve funds to hire an attorney to update their CCNRs or bylaws, specifically to bring them into Ukiah compliance? Next part of that question, when updating CCNRs or bylaws for Ukiah compliance, what is the voting threshold by a homeowners for approval? Can an association use their reserve funds to hire an attorney to update their CCNRs, bylaws, collection policy, and fine policy? If reserves can be used, does a 48-month replacement plan need to be in effect? Are there any other considerations that come to mind regarding pathways to pay for governing document revisions? So, reserve funds are set aside for replacement of reserve components, and reserve components are components that will cost more than 1% of the association's entire budget to replace and need replacing over a long period of time, usually 30 years. So the short answer is the statute is not written to allow using reserve funds for just regular costs of the association. So the longer answer is, and this is, I took this from 6434.384 and 6438.075. So these are the two statutes for condominiums. 6434.384 does apply to Old Act condos. So if you're an Old Act condo, this does apply to you. It states that an association may withdraw funds from its reserve account to pay for unforeseen or unbudgeted costs that are unrelated to maintenance, repair, replacement of the reserve components. And I'm adding this, if you do this, the board of directors shall record any such withdrawal in the minute books of the association, cause notice of any such withdrawal to be hand delivered or sent prepaid by first class United States mail to the mailing address of each owner or to any other mailing address specified by the owner, and adopt a repayment schedule not to exceed 24 months unless it determines that a repayment within 24 months would impose an unreasonable burden on the owners. So if you use reserve funds, you must notify the owners and have a repayment plan of 24 months or less, unless the plan would cause an unreasonable burden. So using reserves for updating governing documents, even policies, etc., could lead to underfunded reserves for other projects. And please remember that insurance companies and mortgage companies are looking very stringently at reserve studies and your level of funding. So it might be better, honestly, to add a line item to the budget to save over time. You're not required, and just a reminder to everyone, you're not required to amend the declaration or bylaws before January 1st, 28. You just have to know where the statute overrides the governing documents and where the documents can be different and comply with the statute. So if you want or need to update your governing documents, just budget for it. Add a line item in the budget and save up for a couple years and you have the costs needed. If you take from reserves, it is fairly risky, but statute does allow you doing that with notice to the owners and a repayment plan. The repayment plan I know some associations may say that additional funding is a hardship and then take 3, 4 years to bring the reserves back to what they were before this withdrawal. That's not what's contemplated under the statute. So if you are intending to do this, be cognizant of the risk. Make sure everything is in board meeting minutes and hope and pray that you don't have a challenge come up in the next few years while you're putting reserves back to where they were. Um, Last part of the question, the voting threshold. It depends on what's in your governing documents. We can't answer that question for any one person or community because the answer can be different. Lisa, did you have anything to add to that?
Just to reiterate your point about budgeting for things, I mean, I think associations in general are loath to increase assessments for any reason, but this is certainly a valid reason, and this is budget season just starting here, coming up in the fall. So this is a perfect time if you're considering doing that kind of thing to add, as Jennifer said, add a line item, and if it needs to be 2 years to pay for it, then so be it. But it's okay to raise assessments if you're doing something for the community, and that's what the budget's for, is to spend the money of the association. So easy enough to add a line item to your documents. I will go on to the next question. What guidance can you offer about ministerial, and that's in quotes as it's a defined term in the statute, about ministerial tasks that require unanimous written consent? My husband is on a board and they haven't been doing that because they aren't clear what that actually means. How do they record it, and where are they supposed to keep a log? What is the statute? So this is the question of the hour, right? When the meeting statute went into effect for all communities in January this year, a bunch of folks are sort of disappointed because no longer could their communities vote by unanimous consent in email and then authorize that or ratify that decision in the next following board meeting, because the statute now says that to do that, you can only cover things that are ministerial tasks. And they don't tell you what ministerial means. So we've had lots of conversations about what that defined or undefined, term is in prior Zooms. I think if you went to our YouTube page and looked and search term as ministerial, you'd probably come up with a few conversations about that topic. This is pretty restrictive. I think you should consider that most topics are probably not ministerial and probably are not appropriate to be used as a way to get out of discussing them in an open meeting, or just time constraint, not having an open meeting. But there are some things that just day-to-day operations, things that might require you to comment or to vote in between a board meeting. And if something is ministerial, which means kind of rote, it's not a voting on a policy, it's not a voting to approve something like a foreclosure. Maybe it is something like a waiver of interest for somebody that might be considered ministerial. I don't know, there's no court cases on this. But if it is something that the board determines to be ministerial, what you would do is each board member needs to vote by email. Nobody can abstain, and all votes need to be voting the same way. So whether it's all approving or all rejecting. The email chain with that last person voting should be basically attached to the board meeting minutes for whatever meeting they're going to be ratifying that decision. Someone would make a motion and say, I approve, or I make a motion to approve the decision made by email on X date regarding whatever the thing was. Someone seconds it, and then the board votes, and that vote is noted in the minutes. And again, then the decision is attached to that. So there isn't really a log, there isn't really a separate record aside from the copy of the meeting, or of the email chain where the board voted to approve it. There are specifics in the statute about about during control about unanimous written consent, things like that. I don't think that's what this person is asking. The rub of this, in my opinion, is all board actions need to be recorded in board meeting minutes. If you're not sure if something is ministerial, it probably isn't, and you should go ahead and hold your board meeting and vote on it in an open meeting and record the result of that motion in the minutes of your association. Anything you want to add to that, Jennifer? It's kind of a hard topic because we don't really know.
I know we've covered it quite a bit in prior Zooms. So if you go onto our YouTube channel and just search the channel itself for videos using the word ministerial, I'm sure you'll get a lot of results. So our next question. If a ratified HOA budget has a certain amount for a line item, as an example, $1,500 for vent cleaning, and a bid is received for $1,300, can the board president sign the proposal since it is below the budgeted amount that the association membership had ratified? Or must they wait for the next scheduled board meeting to do a vote? So there's a couple different issues with this particular question. The first is the board president alone does not have the authority to approve an expenditure. The only authority a board president has is to preside over meetings, and otherwise they're pretty much the same as any other board member with the same authority. So unless the board itself has delegated authority to the board president to sign or approve a bid of at or below X amount, the board president doesn't have authority to take this action unilaterally. So the broader answer really depends on the facts. Was the board president given the authority? Did the board say that if this bid came in under X amount, then it's automatically approved? We don't know the answers to those questions, so we can't necessarily answer it. One point that really needs to be made is inclusion in a budget is not the same as the board deciding to take an action to spend money. Budgets are advanced plans making a lot of assumptions regarding how much certain things are going to cost. At the time a contract is entered into, the person signing that contract needs to have the authority to do that. And the board president alone doesn't have authority to approve contracts. They sign them for the association, but they don't have the authority to unilaterally approve a contract. The board at the time would have more current information and would need to make a decision on whether this vendor is one that they want to use, etc. If the association is over budget on other matters, you may not have $1,300 to spend on vent cleaning. So, long-winded answer, probably not. The board president alone doesn't have the authority to enter into a contract. If the board, the entire board at a meeting, delegated authority to the manager or to the board president, etc., saying if a bid from X company comes in and it's below Y amount, it's approved, that probably is a ministerial action and can be done outside of a board meeting. You've delegated the authority to approve the contract, so it's probably okay. Outside of that, no. The board president alone doesn't have the authority to do that. Lisa, did you have anything to add?
Nope. I'll just go on to the next question. Next question. 6490 seems to allow a reserve study to include a broad range of expenses as long as the cost is infrequent, significant, impractical to include in an annual budget, and necessary for a qualifying reserve component to perform its intended function. We have several expenses that would normally be funded from our operating budget, except that they are infrequent, significant, and impractical to include in the budget. They include things like $50,000 for a drain clean out every 5 years, or $9,000 every 3 years for chimney inspections and cleaning, or $25,000 every 5 years for things like software license renewals. Each of these expenses is required for the component to perform its intended function. Our association is getting conflicting opinions from our reserve study company, from the management company, and looking online. Can you share your thoughts and help us out here? The first thing I would note is this has a lot of specific information. It is probably a little bit too specific for this forum, but we can talk generally about reserve components and generally about your question. RCW 6490010, subsection 47, says that a reserve component means a physical component of the common interest community which the association is obligated to maintain, repair, replace, which has an estimated useful life of less than 30 years, and for which the cost of such maintenance, repair, or replacement is infrequent, significant, and impractical to include in an annual budget. When we talked about this before, we think that the intent is if you don't fund it in your annual operating budget, it belongs in the reserve study. Okay, so it doesn't matter, what the timing is here, but if it's not something that's funded in your annual operating budget, it probably belongs in your reserve study. The reserve study, section 6490.545 sub 2 says that the reserve study must include a reserve component list, including any reserve component, the replacement cost of which exceeds 1% of the annual budget of the association, excluding contributions to reserves for that component. If one of those reserve components is not included in the reserve study, the study has to explain why it is excluded. So it's our opinion, this isn't advice for your specific association, but it's our opinion that of the examples you provided, all of them probably belong in the reserve study if your operating budget is less than $900,000, because $9,000 would exceed 1% of the operating budget. So this is probably something where you need to look at what's the cost of this thing, and if it's not something that we include in our annual budget, it is probably appropriate to include as a in your reserve study. There's a lot of information here, but I think if your association has really specific questions, it's probably appropriate to ask for a legal opinion. But I think as a general case, if it is a fairly expensive component that is not included in your annual budget and it exceeds that 1%, it is likely appropriate to include in your reserve study. Jennifer, anything you want to add there?
No, I think you've covered it. So our next question, can we, when amending or restating our governing documents, change what is defined as part of the unit and therefore change association responsibility to owner responsibility? I'm thinking of attic and crawl spaces in a duplex condo. They're both only accessible from the owner's unit. So the answer is no, generally not. The reason being is that you cannot change the boundaries of a unit without the approval of that particular owner. To change the nature of a component from common to limited common or from common to part of the unit, it requires every owner's consent who is receiving that new component. And the vast majority of owners would not agree. So you can't change the boundary of the unit. You can probably change how responsibility for regular maintenance, repair, replacement, or for the cost of maintenance, repair, replacement is allocated. So you really need to talk to your association attorney when you're redoing your documents about how you want this handled. You can change how costs are allocated without changing the nature of the component. Ownership of a building component, the right to exclusive use of a building component, and the obligation to pay for maintenance of that component are different things and can be allocated differently. Amendment of those three things, so ownership, the right to exclusive use, and obligation to pay for maintenance, those three things can be done differently But in general, changing the nature of a component from common to limited common or common to part of a unit cannot be done without the approval of every unit owner receiving the component. And if you have one owner reject it, then you generally can't do it for everyone. So we, when drafting documents, we don't recommend changing nature of the components because it requires unanimous consent. But changing the responsibility for maintenance or changing the responsibility to pay for maintenance, those can be done a little easier. So for your individual situation, please contact your association attorney. They can better guide you on how to do this and why. Lisa, did you have anything to add to that?
Nope. I'll move on to the next one, which is fairly short and sweet. Um, the question is, I know that HOAs have to offer a free payment option for payment of assessments. Is payment by mailed check considered a free option? And the answer is, it depends if there's additional fees for paying by check. If a mailed check has no processing fee attached to it, that'd be something you'd need to talk to your bank or your payment receptacle PO box company. Then it's free, and that's fine. If paying by ACH is free, then that would be a free payment option. So it really just depends on the agreements you have with any of your vendors as to what is free. You just have to make sure that one of them is free, and it might be mailing a check to your offices or walking in a check to your offices or something like that. But it is certainly possible that that is a free option. It just depends on your agreements and the way that whether you or one of your vendors charges processing fees for mailed paper checks. But that is certainly a good option and one I'm sure some folks would take advantage of. Anything you want to add to that, Jennifer?
No, I think you've covered it.
Okay.
So our next question is, our ACC has two board members, so has ACC authority. We have a board adopted compliance and fine policy which specifies fines with progression of fines based on a specified number of days. Does the board have to approve the first fine and every subsequent fine, or can the ACC follow the fine schedule? So you're conflating two different things here. There's a difference between the board delegating authority to a committee and a committee having two board members. So the ACC having two board members is not enough to grant the ACC any board authority. There must also be some delegation of the authority to the ACC by the board. That could be in the declaration, in the bylaws, in a board resolution, or in a committee charter. So 6490-405 subsection 7 gives enforcement authority to the board. So the board, by statute, is the sole authority on whether or not something is a violation of the governing documents. And the language in the committees section, and this does not apply to all communities yet. So, except for committees appointed by the declarant pursuant to special declarant rights, all committees of the association must be appointed by the board. Committees authorized to exercise any power reserved to the board must include at least two board members who have exclusive voting power for that committee. Committees that are not so composed may not exercise the authority of the board and are advisory only. So, if you have an ACC and you want them to also, the board wants to also delegate authority for enforcement to the ACC, the board can do that. They just need to be clear in board meeting minutes or in a committee charter what authority they're delegating and how that authority is exercised. Once 6490 comes into effect, that committee, if they are exercising board authority, must have at least two board members on it, and those two board members have the only vote. So if the board is delegated the authority to find violations and assess fines, the ACC could do that without board interaction. But the ACC would need to provide notice and an opportunity to be heard before any fine is assessed. And that's true now under 6490-405 and 6438-020. So the board delegating authority to a committee, they can do that. It just means that that particular committee is also subject to the board's meeting procedures under 6490-445, must have two board members who have the sole vote. Lisa, did you have anything to add to that?
No, I think that covers it pretty well. Next question. I recall in a previous Q&A that if a board member attends a meeting remotely by phone, our community does not have the ability to use Teams or Zoom. This option would have to be made to all members of the association. Does this apply if the community association manager attends by phone? And the answer is probably not. There isn't case law on this, so I don't have case law guidance from the court, or I don't have any guidance from the courts on how to interpret these provisions in the statute. The statute we're talking about is RCW 6490-445, again, subsection 3. And that discusses participants. And so the question is whether or not the community association manager appearing by phone is a participant. What's their role in appearing at the meeting by phone? If the person that we're talking about appearing by phone was a board member or another owner, there is not that exception. Then it would need to be made available to all folks. I think the lowest risk option here is to just simply provide the ability for owners to call in. That would be the simplest and easiest provision. You obviously have a way to do it if the community association manager is appearing or routinely attending board meetings by telephone. I will also just make a plug that I know Google Meet and Zoom both have free options. This may be a technology issue that you're talking about, but if it's a budget issue, number one, it is almost budget season, so that might be something to look into if you're wanting to make meetings more accessible to both owners and board and manager. There are free options for a certain number, depending on the size of your community and amount of time. And then I think Google Meet, even after that, it might be $7 a month. So if it's a financial impact on the community, that might be something to look into. But if it's a technology one, I can't help with that. But I think that the short answer is it doesn't hurt anything to allow an owner to attend by phone. The statute's goals at this point appear to be to allow as many owners as possible to participate in the running of their communities. And so I can't imagine that declining to allow someone to attend by phone when you do allow the manager to look great to a judge later if somehow this was challenged. So absent any current guidance on that from the courts, I would say if you're able to, there's no harm in doing it, but I don't think that you are required to do so. Probably. Anything to add, Jennifer?
No, I think you've covered it.
Okay.
So, and this is our last question. So we will have time for a few questions from the chat. So what guidance can you offer for a hold harmless agreement? Are there specific elements that should be included? Should all board members and committee members sign it? And is there a specific statute? So there is no statute for a hold harmless agreement. Hold harmless agreements are specific agreements between the association and an owner, often involving changes to the common or limited common elements for the benefit of the one unit. They're recorded against the unit in order to bind the current and any future owner to responsibility for a modification. We strongly recommend having an association attorney draft the individual agreement or an agreement template to ensure that it's done properly. And we've seen many boards or associations try to draft their own, and for any number of reasons, they fail. One of the major ones is a lot of people just don't record them, thinking that keeping with the association records is enough. and records get lost, if the document is missing or not attached to a resale certificate, a future owner may not be bound by that agreement. So this is one area where you really need to have an attorney who knows what they're doing. Look at these documents and prepare them for you. And a hold harmless agreement may be a modification to the rights and obligations of the owner and the association regarding maintenance, damage, replacement, repairs, etc. Where something is changed from the default in your governing documents, it reflects the new agreement between the owner and the association and can override the declaration or CCNRs. With all contracts, and this is typically a form of contract between the association and the individual owner, you want it to reflect a common, unambiguous understanding of the obligations of each party. So I know a lot of associations want to save money and think that trying to draft something themselves and then have an attorney review it will save time and money. Generally, it costs more for us to fix something that somebody else has drafted than it would be for us to draft it from the get-go. So if you have questions regarding this, regarding a particular hold harmless agreement or what is needed for a hold harmless agreement, please contact your association attorney. The time and money spent answering your questions and getting a properly drafted document is very well spent. We have had clients not do this and run into problems when they can't enforce or can't require a new owner to pay for damage because the owner didn't receive adequate notice of the modification or their responsibility for that modification. Lisa, did you have anything to add to that?
I guess this will be my final comment about AI. Also, please don't have AI draft your hold harmless agreements for us to then review and interpret, because that will certainly cost you a lot more money. We've had that happen, and that takes a lot of your valuable time and money away. And as commented on at the beginning, it is often wholly inaccurate or completely inapplicable to your community. So definitely talk to your attorney to keep your costs down. It sounds illogical, I know, but it will keep your costs down and it will get you what you want.
Chelsea, are there questions in the chat?
I can see a couple of Chelsea's not ready.
I could also read them all.
Okay, that'd be great, Diana.
Yeah,
Thank you.
sure.
Sorry, my mute button did not want to unmute.
Right.
No worries.
Diana can, if you wanted, or up to either one of you.
Yeah, I could do it. First question is there anything in the statutes that would preclude the HOA from prohibiting owners feeding wildlife in a common area or protected areas and or their own lot?
So let's see. I'm trying to recite statutes off the top of my head again. We'll see how accurate I am. So 6434 304, 6438 020, 6490 405 all give the board the authority to regulate the common and limited common areas. So the board can regulate the use of the common and limited common areas. That means that they can prohibit owners feeding wildlife in common and limited common areas. If an owner is feeding wildlife within their lot, that gets a little more specific. You can regulate if it becomes a nuisance. But regulating within a lot or a unit is a lot touchier, so we would recommend talking with your association attorney about if you have the authority to do it and how to go about doing it.
And I would make a plug to make sure that you have actual policies in place that are, talk to your attorney about that. But on other issues, I've had conversations with boards that are doing things because the declaration says they can create policies around an issue, but didn't actually then get the policy done. And so you really do need to kind of go through that whole process. So talk to your attorney if you have something that you want to restrict or control or have some input in to make sure that you have the correct policies in place. And that, as Jennifer's pointed out, that your governing documents allow you to promulgate those rules and policies.
Okay, so the next question is RCW 6490 545 section 2B talks about nominal reserve costs. And the question is, what guidance can you provide on what nominal reserve costs can mean? And I believe it is defined in the statute. It's under RCW 6490-010, number 35. It defines nominal reserve costs. Let's see, as the current estimated total replacement cost of the reserve components as less than 50% of the annual budgeted expenses of the association, but that's for condominiums. And for HOAs, that is 75% of the annual budgeted expenses of the association. And I'll put this in the chat.
So you really got to look to your community and figure out what nominal is for you. But the question about that is, it's a good one. I mean, definitely, but look to see what your actual budget is and whether the cost for that may be considered nominal.
And one thing I'd like to point out, we've run into situations where particular associations have either removed or have never had certain components on their reserve study that should be. So if you have questions or concerns regarding whether or not you have nominal reserve costs or whether you should be doing a reserve study, please contact your association attorney. They're the ones best able to help you in your particular situation.
Okay, I think this might be the last question we have. It is, what are the consequences of going over budget in a given year?
So if
You might not have the money.
yeah,
That's a big one, right? I mean, if you've budgeted for certain expenditures and you've only got a limited number of assessments coming in every month or every year, then you may, at the end of the year, just not have enough for your operational expenses. There are ways to get around that. You may be in a position to do an amended budget or a special assessment budget. If there are expenses that are needed for your organization to continue to operate because your insurance was twice what you thought it was going to be, or your landscaping, or big snow year, or whatever the thing is that caused you to go over budget happened, your legal expenses. So there are ways, to ratify a new budget or to increase income or decrease other expenditures. There might be things like Jennifer alluded to before. If the dryer vent cleaning is approved and it came in less than budget, but you've actually spent all your money, you might have to push that out to the next year.
and please be reminded as well, I know some people think that an association can go bankrupt. And Lisa can answer that part better than I can, but generally associations cannot go bankrupt because they always have assessments coming in. So if you are over budget, you may be able to take from reserve. We do not recommend that. But there are ways to make up that shortfall, and it generally involves a special assessment or not doing things, deferring maintenance, which again raises flags with insurance companies and mortgage companies. The association, the owners should not starve the association trying to keep money for their own personal costs. The association is there to maintain and keep your investment healthy. So if you're getting close to being over budget completely and are running out of money, the board needs to sit down and figure out what the heck is going on and why.
And it's
And
not, yeah, it's hard if you're proud of keeping your assessments low, I think you need to reevaluate, because the goal is not to keep the assessments low. The goal is to keep your association running and preserve your investment. So saying you kept the assessments the same for the last 5 years is not necessarily something that I would be nervous about that if that was the association I was involved. Maybe you have no no community assets aside from the fact that you're an organized community. That might be a separate question, but I digress. I definitely, if you're over budget, you do need to sit down and look at why you're over budget and what things can be done to remedy, either by limiting expenses or by reauthorizing a new budget or a special assessment budget.
Okay, so I lied. There are more questions, but I think we might only have time for maybe one more.
let's take the two at the bottom regarding the budget and savings.
Yeah, I think
So I'm going
those
to answer
popped up
I'm going
as
to
you
answer
guys were
the
talking.
savings one first because it ties into what we were just talking about. So the question is, we have money in savings, never did a reserve study. Is it okay to have money in savings? So you're required to have a reserve study by statute. So if the association does not have a reserve study and is not otherwise exempt, and most associations are not exempt, you need to do a reserve study. Your savings is maybe a buffer for your budget, but it is not for reserve. There are particular statutory provisions regarding reserve funding and reserves. And please know again, it's been all over the CAI listserv that Fannie Mae and Freddie Mac have done another letter for conventional loans, and associations are going to be required to get Fannie Mae and Freddie Mac funding to put 10% of your annual budget into reserves. And I think starting next year, it goes up to 15%. So you need to get a reserve study. You need to follow the reserve study. You probably should talk to your association attorney and figure out how to come into compliance with statute. Because if you're not following statute, that could be a direct violation of the board's duty of care. Because you are not acting in accordance with the statute. So a lot of associations will have a buffer in their annual budgets to carry over to the beginning of the following year to make sure they have enough money to pay expenses starting January 1st. And that's generally fine. Excuse me. But a savings account that does not comply with the statutory requirements for a reserve account, again, doesn't comply with statute. You are not following what you're supposed to do. And honestly, the reserve study is a budgeting tool to let you know how much you need to save now so you don't have a special assessment in the future when these particular components need to be maintained, have maintenance, repair, or be replaced. So just a general savings account that you're throwing money into and hoping you have enough, that doesn't comply with statute. It is not compliant. And then I think we've already answered the question, if we're over budget, can we borrow from reserves? We don't recommend doing that because you're taking money from robbing Peter to pay Paul. If you keep going over budget and just taking money from reserves, you're not going to have enough in your reserves to cover expenses when they become due.
And there are all those specific requirements, that notice to owners and payment plans and all that stuff. And if you can avoid having to do all that, that'd be great.
Yeah.
It's a pretty specific process. But it looks like we're at 11 o'clock, Jennifer. I
Oh,
think we're.
Yeah, I can go on about that for a while. So
Thank you
thank
all
you,
for
everyone.
coming
Have a
today,
great
and
day.
we'll see you next week.